My name is Mitch Olson. I am a partner at Olson. My law practice focuses on litigation with an emphasis on real estate, land use, and municipal law. The purpose of this video is to give you a brief overview of how Wisconsin's newly effective comprehensive planning law, commonly referred to as the Smart Growth Law, is designed to work. Those involved in land use decisions, from either a municipal or landowner perspective, need to understand how the Smart Growth Law may affect their actions and decisions. Until 1999, Wisconsin statutes allowed for local governments, including counties, cities, villages, and towns, to engage in comprehensive land use planning. However, in most instances, municipalities limited themselves to a local zoning ordinance and subdivision control ordinance rather than a comprehensive plan. Even in a municipality where a plan was adopted, Wisconsin law did not require that the municipality's land use decisions follow the plan. Given escalating development pressures and associated growing pains, such as loss of agricultural land and rising costs of municipal services for new growth, many observers called for legislation which would encourage comprehensive planning with some teeth to address these concerns. Through legislation in 1999 and 2000, the Wisconsin legislature adopted comprehensive planning law. It originally was structured to require a city, village, or town, if exercising village powers, to adopt a comprehensive plan in order to engage in certain land use activities. Most notably, it provided, beginning on January 1, 2010, if a local governmental unit engages in subdivision regulation, zoning regulation, and shoreline zoning regulation, those actions shall be consistent with that local governmental unit's comprehensive plan. Because almost all local governments rely on zoning and subdivision laws, this essentially was a mandate to engage in comprehensive planning. The teeth of this planning law was the consistency requirement. Thus, under the original law, if a governmental unit engaged in subdivision regulation or zoning in 2010, such actions were required to have some undefined measure of consistency with the plan. For example, if a residential subdivision were approved, that subdivision must be consistent with the plan. Likewise, the application of the zoning ordinance or any amendment thereto or variance therefrom must be consistent with the plan. It was widely noted that the law did not define the meaning of consistent with. There was the expectation on many fronts that litigation would be required to establish a definition. Until the Court of Appeals, and likely the Supreme Court, ruled on that provision, over the course of perhaps several years, the law would be subject to great uncertainty, litigation, and possibly inconsistent results. Although this uncertainty remained during the period of 1999 to 2009, many local governments across the state worked through the process of preparing and adopting comprehensive plans. Within months of the new law taking effect in 2010, the legislature took significant action to define the consistency requirement. In the process, it chose to weaken that requirement in several respects. First, the amendment defines comprehensive plan as a guide to the physical, social, and economic development of a local governmental unit. Second, the amendment adds a definition of consistent with to mean furthers or does not contradict the objectives, goals, and policies contained in the comprehensive plan. Third, the amendment changes the application of the consistency requirement. The former version required that any local government engaging in the actions of subdivision regulation, zoning, and shoreline zoning must act consistent with its comprehensive plan. The new version only requires that the certain ordinances be consistent with the plan. The new amendments define the term consistent with and in the process include two elements which weaken its ultimate effect. First, the amendments only require that the local government make a finding that a covered action furthers or does not contradict the plan. This leaves significant discretion to the governmental body. It is not a strict consistency standard. Second, the amendments limit which land use actions must be consistent with the plan. The prior version required that all subdivision regulation, zoning, and shoreline zoning be consistent with the plan. The new version simply demands that new ordinances should be consistent with the plan. The application of those ordinances, however, is not required to be consistent. There is an implicit assumption that so long as the ordinance is consistent, all applications of the ordinance will also be consistent. These 2010 amendments to the Comprehensive Planning Law will affect how local communities apply their new plans in their day-to-day land use activities. While the amendments give greater certainty in applying the law, they also allow significant discretion to local governments, weakening the effect of comprehensive plans. As this new law begins to be applied, many questions are likely to arise. If you are involved in the land use process and have questions on how the comprehensive planning law affects your proposal or decision-making, Axley-Brynolson's Land Use and Zoning team can help. Feel free to contact me directly at 608-283-6724 or email me at molson, molson, @axley.com.